Yeah, just we'll discuss today. Sorry. So we'll start with the Official Secret Act. So Unit 5, I believe. So how it will be, what kind of a section? So what is the how the what are the provisions in the Official Secret Act will just highlight, and so what kind of rules and procedures in this Official Secret Act. So Official Secret Works Act 1923. So Official Secret defined as a piece of confidential information. So important for national security, should be protected. Just give me 1 minute. Just somewhere. Yes. Okay. Yeah, so official secrets, what do you mean, how it defined? So a piece of confidential information that is important for national security, it should be protected. So under this law, so whatever the piece of information, what is crucial information that is lying with them in government of India official, any kind of a department, so maybe related to the defense, it may be related to any kind of a confidentiality, any kind of a information, piece of information. So that is government feel, so government feel and believe and deem that the confidential, so it will not be shared, it will not be, we cannot able to access that kind of information. So we would need to access the information, we need to get the permission from the government of India, or maybe kind of a respective state government as well. As so that way, such kind of a guidance, such kind of a procedure is laid down in this act. So which information we need to just seek, which information we should not seek. So that kind of act is anti espionage, spice, or a secret agent act that came into force in the year 1923. So the act extends to the whole country and applies also to the servants of the government and to citizens of India who are living outside as well. As the act states that one cannot approach, inspect, or even pass over a prohibited place or government site. So we will just feel, will see the certain kind of a places, certain kind of places, kind of a, suppose we'll just you can inspect certain kind of a places, like national dams are there, so where the close encroachment is prohibited, so you cannot take the photographs, you cannot get into the inside the dams, like Nagarjunasagar Dam, where in a certain kind of a area prohibited, where you cannot enter certain kind of areas and places. So this act will just focus, it also just highlight certain areas, certain places we cannot visit, you cannot inspect the certain kind of a places. The act prohibits the disclosure of any information that is likely to affect the sovereignty, integrity of the country, the security of the state, India, and friendly relationship with the foreign state as well. As so that is the way this act speaks about. It prohibits the disclosure of any kind of information, any kind of information that is likely to affect the sovereignty, Indian sovereignty, and the integrity of the country. So it may disintegrate the country, maybe on the basis of the cash, creed, and any kind of information that may able to affect the integrity of the country and sovereignty and the security of the state, or friendly relations with the foreign states. So that's the way the Official Secrets Act prohibits. The Section 3rd of the Official Secrets Act prohibits the free reporting. If any sketch, plan, model, article, note, document, or information relating to are used in any prohibited place or relating to anything in such a place or any secret official code or password is made, obtained, collected, recorded, published, or communicated by any person other than a person acting under lawful authority from the circumstances of the case and his conduct, his known character has proved, it appears that his purpose was purpose judicial, prejudicial to safety or interest of the state. So that is the way. So Section 3 of the Official Act prohibits certain kind of a news, certain kind of a information, certain kind of a sketch, certain kind of a plan, certain kind of a note, article that is related to the government of India that is, I mean, unlawful. You cannot able to access this certain kind of a documents and information, article or model or plan of any information. So with is able to just he attract the penalty as well as the act prescribes the punishment with the imprisonment up to 5 years or fine or with both for a person who voluntarily receives or communicate any official secrets or official secrets. I mean, who will able to share the information. So penalties for spying and punishment under the act. The punishment of spying, the official secrets act ranges from 3 to 14 years of imprisonment. So the person who is indulge in certain kind of activities, who are able to procure, who are able to access certain kind of information that will able to access and able to publish certain kind of information, so likely to just get the punishment ranging from 3 years to 14 years of imprisonment if any person, any purpose harmfully to the safety and security of the interest of the state, so access the information, approaches, inspects, passes over, and is in the in vicinity of a particular place or maybe enters any prohibited place or makes any sketch, plan, model, note which is circulated to be might be or intended to be directly and indirectly useful to any kind of any to any enemy or obtains, collects, records, publishes, or communicates to any further persons any secret, official code or password, any sketch, plan, model, article, note, other than documents and information which is circulated to be or might to be or intended to be directly, indirectly useful to any enemy, which is led to a matter of disclosure of which is likely to affect the sovereignty, integrity of the India and security of the state or the friendly relations. This is the way. So whatever the information before just writing, before you just printing the any kind of information related to the government of India, it will consider, it will believe, it will deem that certain kind of information has been under the coverage of the official secret acts. You cannot access, you cannot venture, you cannot just go to the we should not go to the prohibited place as well as. So there those who will involve certain kind of a access, there will be a penalty up to the 14 years of imprisonment and maybe likely to be just imposed fine as well as. So right, next we moving on to the next element. So right to information act. So right to information act 2005. So what it is mean by it? So what how it will be done? So right to information act was enacted on June 15th, 2005. So it came into force on October 12th, 2005. This act was enacted to provide for setting out the practical regime of the right to information for citizens in the country to secure access to the information under the control of the public authorities in order to promote accountability and transparency in the working of each public authority or institutions. This acts covers the whole country. So just give me 1 minute, some kind of a disturbance here. Just 2 minutes. Sorry. Sorry for the delay. So leave it like some problem. Just okay, rectified. Right. Just we're discussing Right to Information Act 2005. So how it will just brought about. So it will just started came into force on October 12, 2005. So the act covers the whole country. So this act covers all the constitutional as institutional authorities, including the executive, legislature, judiciary, or any institution, organization, or body established and constituted by the act of parliament as well as the
Right of
state.
Information Act.
Sorry,
దీని స్లైడ్ సార్ చెప్తున్నారు సార్.
sorry, I didn't get you. Yes, Madhusudan garu.
సారీ సార్ అని చెప్పు.
సార్ వాయిస్ డిస్టర్బెన్స్ సార్, మీరు కంటిన్యూ చేయండి సార్.
Okay, right.
Yeah, sir. Sorry, sir. Please
Yeah,
carry on,
no,
sir.
no. Okay. Yeah. So any information that we need to seek, so we need to just seeking any kind of information. So the public sector, so you can just access, you can seek information. So that is the way. The I mean this I mean Right to Information Act is came into force. So that is the main kind of it will try to just provide transparency. So the person who is seeking would just willing to just know what kind of activities, how the government of India is spending on its schemes and kind of where the information, how the recruitment process is followed, there certain kind of irregularities are there, certain kind of any kind of misappropriation in the fund allocation is there. So there's such kind of information, such kind of content you can just seek, you can just ask for the government of India or maybe any body, any department, you can just ask the information based on this Right to Information Act. So in this Right to Information Act, there will be Central Information Commissioner is set up under the Right to Information Act 2005. So he is authorized body to establish it in 2005. So to act upon the complaint received by them, the CC Central Information Commissioner. So consists of one chief. Information commissioner and not more than 10 information commissioners. The CIC and the IC information commissioner are appointed by the President of India. The state information commissioner will be constituted by the state government through a gazette notification, and it consists of one state chief information commissioner and not more than 10 state information commissioners. They are appointed by the governor of the concerned state. So how the appointment will be done? So who will mean just who is the appellate authority in the state? He is the appellate authority in the state is the state information commissioner. He is the state appellate authority. So there will be commissioners will be there. So where suppose we will feel that mean certain kind of information is not provided, so you can just ask, you can just file your complaint to the state information commissioner. So this, the act specifies the time bound as well as schedule for replying to the RTA applicant request as well as who will made, just, want to seek information. If the request has been made to the public information officer, so the reply is to be given within 30 days from the date of the receipt of the application. So minimum 30 days it will be given the time. So if the request has been made to the assistant public information officer, the reply is to be given within 35 days from the date of the receipt of the application. So that kind of whom we are just making a request. If the IPIO, so public information officer, transfer the information request to another public authority, the time allowed to reply is 30 days, but the calculated from the delay, calculated the day after it is received by the public information of the transfer authority. So that way, suppose certain kind of information he is not having certain kind of, you can transfer the request to the other concerned authority as well as the information regarding the corruption and human rights violation by scheduled security agencies, etc., is to be provided within 45 days, but with the proper approval of the Central Information Commission. So at in life or liberty of any person is involved, the public information officer is expected to reply within 48 hours. So this is a time bound, this is a time stipulated time. So in this particular stipulated time, they have to react, they have to just give the information to the person who is willing to just seeking kind of information. So information accepted to disclose under this article, the Right to Information Act. What are the procedure? What are the aspects? The disclosure of information which would prejudicially affect the sovereignty, integrity of the country, security and scientific and strategic and economic interest of the state, relation with the foreign state, or any thing which lead to the incitement of any kind of offenses. So such kind of information believes government believe or commissioner believe that certain kind of information will infringe certain kind of incite the groups or maybe likely to just come likely to disturb the communal harmony. Certain kind of information if the commission believes it will not able to public relation officer believe cannot give the certain kind of information. The disclosure of information which has been specially prohibited to be published by any tribunal or a court of law, or the disclose of the information which may constitute contempt of the court. Next, disclosure of information which would cause a breach of privilege of the state legislature or parliament. Certain kind of information will not be provided. The information is received in confidence from the foreign government, or information which would hinder the process of investigation, any kind of apprehensions. So if you feel we the government or maybe the concerned authority feel certain kind of information will able to just would able to disturb the process of the investigations, so any kind of activities, so that way it will not able to just give it will not able to just give information on such conditions. So next, moving on to the cyber laws as well. The Information Technology Act, the cyber law came into force on October 17, 2000. So deal with the cyber crimes and electronic commerce, e-commerce. It will call it electronic commerce, e-commerce in the country. So the act applies to the people in the country along with the other national if they are charged with charged under the law, and if the crime involved a computer network located in the country. The IT Act provides a legal framework for electronic governance by giving recognition to electronic accounts and records and digital signatures. So this is the way it will the scope, the parameter it will covers. So whatever the kind of a information, the kind of a activity using the network or maybe uses the computer. So involves any kind of a activities, electronic commerce, or maybe any kind of a legal framework that governance recognition of to electronic accounts or records and digital signature of the you can disturb the kind of any kind of activities of the government as well as the individual. The tampering, the offenses and penalties under this act. So tampering with the computer science, computer sources, as well as how it will be under section 65. So under this act, if an individual knowingly or intentionally hides or destroys or changes, or intentionally or knowingly causes another to conceal, destroy, or alter any computer network or program or source code, when the computer source code is required to be preserved or maintained by law for the time being in force, the person is imprisoned up to 3 years and with fine up to 2 lakhs rupees. This is section will just highlight. So whoever knowingly, unknowingly causes or are able to destroy or able to alter the computer network or maybe a program or a password, may be likely to just get the fine up to 2 lakhs or maybe imprison up to 3 years. The hacking section 66 of this act will says if a person intentionally damages or destroys or deletes or alters any information residing in a computer resource or diminishes its value or utility, etc., will be imprisoned up to 3 years or a fine up to 5 lakh rupees under this section, hacking kind of section. So hacking any particular person's information or just hacking the any computer, any particular person computer, or maybe any kind of website, or maybe government website, or maybe any person's websites. So without accessing, without permission. So I'm just, where it will just alter, it will able to just delete any kind of a program, any kind of a information related to any maybe government of India website, or maybe any kind of a particular person or organization information, where a certain person will be able to just get fined for can find or maybe in prison for up to uh, 5 lakh rupees. So, or maybe in prison for 3 years. Next, under section 66A, any individual who sends by means of a computer resource, so any information that is completely offensive or any information which he she knows to be incorrect. So certain kind of information. So under 66A, so such kind of information that will be able likely to get the imprisonment as well as when fine. So next, receiving stolen computer devices, section 66B highlights. So if a person receives or keeps a computer device which is known to be stolen, etc., is liable to imprison for a period up to 3 years or maybe fine up to uh, 1 lakh rupees. So certain kind of a stolen computer that devices they will just keep hold or maybe just having possessing such a kind of a devices such as kind of a computer. So that will be likely to just get the fine up to 1 lakh rupees. Using the passports of another individual as well as section 66C, he'll just highlights if a person illegally uses the passwords, digital signatures, or other unique identification of another person is imprisoned up to 3 years or with fine up to 1 lakh rupees. So this is, I mean, possessing any kind of any other person's password illegally or maybe digital using the digital signature of the particular persons. So that kind of a in such a case you can just imprison for 3 years or maybe they will fine for, I mean, up to 1 lakh rupees. So cheating using the computer devices as well as under section 66D, if a person cheats, I mean, someone using the computer resources or communication is in prison up to the 3 years and the fine up to the 1 lakh. This is a section. So how each section has a certain kind of a uh, uh, aspects that will highlight so how it will be just affecting the individual or maybe institutions or maybe corporate world or maybe any kind of a government organization, government department. So whoever infringes certain kind of a laws, that will be likely to just attract the penalties as well as the imprisonment. So one more thing on section 66E, publishing a private images of other persons. So if a person captures, transmit or publishes pictures of a person's private parts without his her permission or knowledge is imprisoned for a period up to 3 years and with fine up to 2 lakh rupees. So publishing a private images of the any person. So this act will prohibits. Next, acts of a cyber terrorism, section 66F. If a person access a protected information with the intention of threatening the unity, integrity, sovereignty, security of the country is called cyber terrorism. He will be imprisoned up to a lifetime. So this is, I mean, this is a crime. This is, I mean, more crime. So which where people, I mean, cyber whoever involved in such kind of activities that will be infringed, that will be violated, that will be I mean, disarming the country as well as the integrity and the security of the country. Such kind of a act, such kind of a initiative, such kind of a any kind of such kind of a initiative act will be likely to just considered as a cyber terrorism and just will be in prison for up to lifetime as well as. So next, publishing the obscene information. So section 67. So if a person publishes or disseminates information or any material in any form in electronic form which is obscene, such information is tend to deprave or corrupt person who are likely are having read, seen or heard the matter. So that kind of a publishing the obscene information. So publishes or may kind of a circulates or disseminates information material in any form, so in any electronic form which is considered obscene. So that kind of information, so the particular person should not circulate and this should not disseminate such kind of a information. Next, publishing the images containing the sexual acts, section 67A and 67B. Under this section 67A, if a person publishes or disseminates the images containing a sexual explicit act or conduct is imprisoned for up to 7 years and with fine up to 10 lakh rupees. So under section 67B, child below 18 years, born in online, etc. If a person captures, publishes, disseminates of a pictures of a child in a sexually explicit act or conduct, or if a person induces a person child into a sexual act, etc., will be imprisoned up to 5 years and with fine up to 10 lakh rupees on first conviction, up to 7 years imprisonment and with the fine up to 10 lakhs rupees at the second conviction. So that is the way. So first conviction, second conviction, the kind of a penalties. So whoever been just pass on, who just involved, who has been incitement, who just explicitly use this kind of a this kind of a events, kind of a acts will likely to just on first conviction it will be 5 years or maybe 10 lakhs, and second conviction if it is there, so it will be 10 lakhs rupees. It will be in prison for 7 years. So that is, child related cyber crimes, how it will be just whatever the initiatives, whatever the acts, the acts, how it will be the rules of the particular the particular act, how it will be just affect whoever will misuses, whoever just indulge such kind of act, we will be likely to just have imprisonment as well as fine up to 10 lakhs rupees. So moving on to the next act, Intellectual Property Rights and the Copyright Act 1957. So what is the Intellectual Property Act? So what is the intellectual property rights? Are the rights and protections granted to the owner or creator of the intellectual property. The intellectual property rights include trademarks, copyright, patents, geographical indicators of the goods, and industrial designs, in some other country trade secrets as well as. So this is how it will be considered intellectual property acts. This is, property rights means kind of thing, any kind of a thing, so that will be just highlighting the using the misusing the trademarks, or maybe the copyrights of the content, or maybe copyright of the any kind of a creative or act creative, maybe it may be related to the sound, it may be related to the music, it may be related to the any kind of images, and maybe the graphical representation. So it will use without kind of any particular person who has done, who has been just created. So that way it will be, that will be considered as the under the Copyright Act. It will be likely to just before just using such kind of a art content, you need to just take the permissions on maybe patents and geographical indication of a goods on industrial designs that will be considered the intellectual property rights can under the sorry the intellectual property rights. So next, duration of the intellectual property rights. So what are the duration of the particular property rights? So the patents will be protected for 20 years from the date of the filing of the particular patent application. So it will last for 20 years. So trademark registration is valid for 10 years from the date of filling an application, which is considered to be date of registration of a trademark. It will be renewed early, next every 10 years, they can be able to renew, as well as it will be for registration of a trademark, it will be lasting for the 10 years. Next, copyright generally lasts for a period of 60 years or the author's lifetime, or plus 60 years thereafter. So it depends on the copyrights kind of it will be lasting for 60 years or the author's lifetime, as well as it depends on the thing. And those who are using the content, they can also just enable to just pay royalty as well as. So we'll discuss in later the kind of a loyalty as well as. So the layout design is for 10 years. So from the date of filing of the application for registration. So layout design, so maybe graphical design as well as any kind of a creative work. So that will be for 10 years. It will be lasting for 10 years from the date of filling application for registration as well as. For protection of registers, crop varieties, etc. So 18 years of trees and vines, and the 15 years for other crops, existing varieties, or a geographical indication of goods for 10 years. So initially 10 years well, and can be renewed forever. So that way, this is the duration of the property, intellectual property rights. From time to time, they can have certain kind of a time duration as well. So IPR laws in India. So India, there are different acts which protect the intellectual property, including the Patent Act 1970 as amended in 1999. So 2002 and 2005. So Patent Acts as from time to time it amended. The Copyright Act 1957 as amended several times. The latest is being 2001, subject to correction. So I need to check it, cross check this as well as again it will just re-modified in 2018, I believe. So the Trademarks Act 1999, which is abolition and replaces the Trade and Merchandise Marks Act 1958, and passed by the Indian Parliament on December 23, 1999. So next, a sui generis registration called the Geographical Indication of Goods and Registration Protection Act 1999 came into force on October 23rd, 1999. So next, Design Act 2000. So Design Act. So basically for when designing the graphical representation or maybe creative content in the form of the graphical representation. Next, Protection of the Plant Variety and Farmers Rights Act 2001. So it will protect the certain kind of a variety seeds. So for a particular time, so it will just register, it will just file an application, it will be last, it will be under this act, it will be covered. The semiconductor, the integrated circuits layout and design act 2001. So this is a semiconductor kind of any kind of a chips, any kind of a mere integrated circuits that will cover under this act, design act. Next, copyright. Just will discuss about the Copyright Act 1957. So copyright is a set of rights given by a law to just created the literary, musical, dramatic, artistic works, and the producers of the cinematograph, graph, films, and sound recordings, etc. So the copyright law protects these works by law in the country. So any kind of a act, any kind of a content created by literary, maybe musical, maybe dramatic, maybe artistic kind of works. So whoever produces this it will just this kind of act will cover the any kind of a sound recording as well as copyright protects these works by law in the country. Copyright is exclusive rights given to the author, creator, owner of the work under the section 14 of the act, which reads in case of literary and musical or dramatic work to do and authorize the doing of any of the following deeds, namely any material, form, or reproduce. So there's a certain kind of a procedure, certain kind of a guidelines. So if you want to use certain kind of a musical or dramatic work or literary work, so what kind of attributes, what kind of deeds, what kind of you just use the same kind of a content, same kind of a creative work. So for any material to just form, so use the same kind of a material to reproduce and the reproduce the work in any material form. So the kind of a reproducing as well as any kind of a using same or reproducing same kind of a material as well, and making a copy of the film, same copy of the film, just you will not use the same copy of the film and communicate the film by radio transmission. So same film or maybe video or maybe you cannot just transform or maybe you can use for radio transmission as a or produce or reproduce, perform or publish any translation of the work as well as. So these are the conditions that will under this, Copyright Act 1955, you cannot reproduce, you cannot remake. So before remaking or before reproducing or maybe using for public exhibition as well as you need to just you need to take the permission of the concerned persons. So before initiating, before taking up such a kind of activity, such a kind of a measure to use without kind of information, without kind of a knowledge of a particular author who is owner of the content. So you need to just take the permission from the concerned person. So that is the way a Copyright Act will just, use certain kind of a permission before take you need to take the permission and then you can use after I'm just getting the permission from the concerned person or concerned owner. Next, moving to the right to privacy. So right to privacy means the right to let a person live on their own, the right of a person to be free from unnecessary publicity and right to live without unjustifiable interference by the government or any private individual or any other third party in matter with which the public is not concerned. So the public is not concerned. So public, when this public is not concerned, it's an individuality, it's its own way. He can live his individual, he can have his own individuality and he can live his own way. So that way nobody can able to just interpret, nobody able to invade, nobody to intrude in its privacy. That is this right to privacy acts guarantee a particular person he can live as per his wish and as per his will. So as per a certain kind of individuality. So right to privacy is not specifically guaranteed as a fundamental right. in the constitution, but later on it's implied in the right to life and personal liberty under the Article 21 of the Indian Constitution. So that is a constitutionally guaranteed, is not guaranteed initially fundamental right. So, but Article 21, it's been layout and it will be just highlighted under the, I mean, life, right to the life and personal liberty. So under this section, under this article, it will just give the person to just live according to his will and wish as well as on his own. The right to privacy differs from the private persons to public persons. So this is, I mean, differentiation is there. So the person who is, I mean, in a public life, so there is a kind of a differentiation. So we need to just need to just identify the differentiation. The public person who functions under the public gaze, like public representative, etc. So maybe politician, maybe public figure, maybe public person who may be considered, maybe not accept the same amount of privacy like a private person. So they may not have certain kind of a same kind of a right to privacy. So it will, when it comes to the public person, when it comes to the public personality, so the same kind of a public the concern, the kind of a concern, the kind of a privacy may not be prevail, may not be have the public figure. So that, I mean, like, I mean, private person as well. So the public representative, a public person who works under the public gaze. Public gaze means who is, I mean, public person, who may be a bureaucrat, maybe it may be a politician, or maybe a celebrity. So his acts and conduct, even if conducted in a private, may be brought to the public attention, knowledge through any medium of communication like press, electronic media, etc. So that is kind of a way. So that way that will feel. So whoever I mean, particular person who is, I mean, believed, who's been, I mean, deemed that he is a public figure, such a kind of a particular person will not have the such a kind of a right to privacy, uh, cannot be behaved. So under, I mean, public with the any such kind of a act, such kind of a particular person's activity cannot be published, cannot be can be relayed, or maybe cannot be telecast. Such way public particular person who's been responsible, who's been feel certain kind of a responsibility, who's been considered as a role model for the many people, such kind of a person will not have such kind of a right to privacy as well. So this act defines and specifies powers of a courts in punishing and contempt of courts. Sorry, we are discussing, we'll just get into this another act, the Contempt of the Court Act 1971. So previous we'll discuss about the Right to Privacy Act. So who are the main person, the kind of a differentiation. So who is a public figure, who is the main private person, whoever in the public life who is considered the main public figure, and who is a particular person who is not, I mean, nowhere. He's, I mean, personal life. He can lead his personal life. Nobody can able to intrude his in his privacy. He's allowed to just live his according to his will and wish as well as who the other way, the particular person who is, I mean, responsible, who is considered as a role model, who has been public figure, who is, I mean, he may be a bureaucrat, he may be politician, so he may not enjoy same kind of a privacy. So when compared to the private individual, so that is the way how it will differentiate. So we just moving on to the, I mean, Contempt of Court. So Act 1971. So what are the, I mean, Act is will highlights what kind of a limits in this acts highlighted. This act defines and specifies the powers of the courts in punishing the contempt of courts and to regulate their procedures is extended to the whole of India, except to the extent to which the provisions of the act relate to the contempt of the Supreme Court as well as. So provisions extended to the whole country as well as. So certain provisions as Supreme Court of, I mean, procedures and the kind of a judgments. The contempt are two types. They are classified as civil and criminal contempt. Civil contempt means willfully disobedience to any judgment, decree, and direction, order, writ, or other process of a court, or sorry, willful breach of an undertaking given to a court. So this is a civil contempt. So means willfully disobey obedience. Disobedience means you will just disobey any kind of a judgment. So disobedience, so whatever the judgment, whatever the I mean, degree, whatever the, I mean, directions given by the court, you disobey the court order, disobey the court writ, disobey the process. So that way it will feel that will just infringe, will just able to just disobey, where willfully disobeying the any kind of a judgment there. Next, criminal contempt is means the publication, whether the by words are spoken or written or by signs or visible representation or otherwise of any matter or the doing of any other act whatsoever, it will consider as the criminal contempt of the court. So this is a differentiation between the civil contempt of the court and the criminal contempt of the court. So, civil contempt of the court will be willfully disobedience of the court orders. In criminal contempt is the publication of any publication. It may be in the form of the spoken words, it may be in the words, it may be spoken or written, or by any kind of expressions, any kind of a signs that will represent the kind of a publication, the kind of a matter doing any kind of a act, it will be considered as a criminal contempt. So this is certain exemptions for contempt are defined by the act include certain kind of a exemptions also just given in this act, as well as fair and accurate reporting of a judicial proceeding is not contempt. Publishing a fair and accurate report of a judicial proceedings or any stage thereof. So whatever the judicial procedure as well as a publishing fair and accurate report of a judicial proceedings, it will be considered, it will be as the exception as well as fair and accurate reporting of a judicial proceedings. Next, fair criticism of the judicial act, not contempt. So fair criticism, a person shall not guilty of a contempt of a court for a publishing any fair comment on the merits of a any case which has been heard and finally decided. So such kind of a fair criticism should not be fall under the contempt of the court as well as. So next, complaint against the presiding officers of the subordinate courts when not contempt. A person shall not be guilty of contempt of court in respect of a person, in respect of any statement made by him in good faith concerning the presiding officer of any subordinate court to any other subordinate court or to any high court. So there also the complaint against any kind of a presiding officer, that is also not considered under the contempt of the court. Publication of information relating to the proceedings in chambers or in camera, not contempted, except in certain cases. So certain cases where the proceedings of the chambers, I mean information related to the proceedings in chambers or maybe a camera, so that will be cannot be considered as a contempt of court, but there will be a certain kind of exceptional case. So we need to just take the permission of the court as well as we take the permission of the judges as well as before just capturing certain kind of movements as well. So limitations for the actions for the contempt of a court as well. So no court shall initiate any proceedings of a contempt after 1 year from the date on which the contempt has been committed. So no court shall initiate. Initiate means so after contempt, the person who's involved. So after whoever involved. So after 1 year, the date from the 1 year from the date of on which the contempt has been committed. So the kind of a 1 year, after 1 year you cannot, the court cannot initiate, cannot use the contempt of procedure. This act does not apply to contempt of Nyaya Panchayats or any village court. So that is a limitation is there. Provision of this act shall be in addition to the provisions of any other law relating to the contempt of courts. Next, Supreme Court or the case may be or any High Court may take rules for any matter relating to the procedure. So this is, I mean, limitations of the actions of the court of contempt. So that's how it will be few limitations as well as, I mean, directions, how it will be, how we will use on which are the aspects which will not fall under the contempt of court and what are the limitations. So that way, how we will just need to see. So before just reporting any kind of a, before commenting, before just criticizing any kind of a procedures, any kind of a acts, any kind of a writ, so any kind of a directions given by the court of any court. So that is there. So next, moving on to the next, indecent representation of a woman Prohibition Act 1986. So this is the act. This act prohibits indecent representation of women through advertisements or in any publication, writings, paintings, figures, in any other manner for what for what matter conducted therewith are incidental thereto. So provision of advertisements containing indecent representation of women. No person shall publish or cause to be published or arrange or take part in publication or exhibition of or any advertisement which contains indecent representation of a woman in any form. So this act covers the indecent representation of a woman. Next, prohibition of publication or sending by post of books, pamphlets, etc., containing indecent representation of women. No person shall produce or cause to be produced, sell or let to hire, distribute, circulate, send any book, pamphlet, paper, slide, film, writing, drawing, painting, photograph, representation or figure by post which contains indecent representation of women in any form. So that's also provision of such kind of a publication or any kind of a book or maybe any kind of a pamphlet. So where it will be containing any kind of a indecent kind of representation of any representation of women in any form, maybe falls under this act. And any search and seizure can be made under the Code of Criminal Procedure Act of section of the 1974 or Bharatiya Nagarik Suraksha Samiti. So that is how the criminal procedure was renamed. So Bharatiya Nagarik Suraksha Samiti, and inform the nearest magistrate and take his orders for the custody. If found the guilty and the first conviction, she may be awarded imprisonment of the maximum 2 years and a fine up to 2,000 rupees. So if it is repeated, the imprisonment shall be for maximum 6 months, but may be extended to 5 years. Fine maximum rupees 10,000 rupees and maximum fine up to 1 lakh rupees would be awarded. So this is the way how any kind of a just find such kind of a act, such kind of a material. So under criminal code of criminal procedure and Bharatiya Nagarik Suraksha Samhita, so if you find any kind of indecent paper, indecent kind of a book, so that is indecent representation of a woman, so he will be produced before the magistrate, and just the on the conviction, the first conviction, the fine will be 2 years. The fine will be for up to 2,000 rupees, and it will be imprisonment up to maximum 2 years. So that will be second conviction. It will be 1 lakh rupees, and it will be 5 years imprisonment. So offenses to be cognizable and bailable. Certain kind of this bailable as well as an offense punishable under this act shall be bailable and cognizable where accused can be arrested without warrant. So, in fact, there is a need to invoke this act more often in press and electronic media. So, this kind of a act is just more common. So, just used in press as well as electronic media. Next, moving on to the second one. Sorry, just give me 1 second, 2 minutes. Yes, thank you. Just moving on to the censorship law. So censor, what it mean by? So censor literally means a person whose job is to read books, watch films, etc., in order to remove anything offensive from them. So any kind of information. So this mean Oxford Dictionary, it will just given the definition. So any literary person means a person whose job is to read kind of any kind of a information, any kind of a act that is focused, that is presented in films or maybe books. that able to just attract the any person, authentic person will able to just censor certain kind of elements and kind of any kind of a caricature, any kind of a video, any kind of a scene in the film as well as. So censorship in India is exercised through the legislation such as in Section 153A and 153B of the Indian Penal Code 1860. So and the Cinematograph Act 1952. So this is two sections 1951A and 1951B. So this censorship in India is exercised and just through just brought and just introduced through legislation. So Section 153A of the Indian Penal Code, so Bharatiya Nyaya Samhita deals with the offense of promoting disharmony, enmity, and feeling of hatred between different groups on the ground of religion, race, birthplace, residence, language, etc. Doing acts are prejudicial to maintenance of the harmony. So this is basically 153A will just highlight the kind of a acts that will be just promoting any kind of a disharmony, any kind of a enmity, any kind of a feeling of hatred between different groups, different ethnic group, as well as any kind of a religion. It will be any kind of a discrimination of the based on the race and place of birth, any kind of a residence and language, as well as these are the acts will just it will this section will discuss just highlight any kind of a infringement of any kind of involvement of any kind of a promoting this kind of activities will be covered under this censorship. Next, section B, 153B, deals with the offense of the imputations and assertions, etc., which are prejudicial to national integration. This is any kind of a national integration, so that will be this infringes and kind of a disintegrate the national integration. This act will be dealing with the offense, any kind of a offense will dealing with the integration of the national integration of the country. So next section 124A of the IPC and Bharatiya Nyaya Samhiti 1860 deals with the offense of the sedition. So 160, 124A, this is more oftenly used. So actually this 124 section 170, 124A was brought by a British government. So the main intention was to those who were involved against the British activity, British government, such kind of activities, who will just involve such kind of activities against the British government. So this section was brought into the force and use this section to just put behind the bars. Indians will use this section to just arrest the Indians. So this is considered the Sedition Act, even though this is act was used and sometimes a certain kind of a way that will be misused. Kind of there is allegation that this is very often is misused. So under this provision, whoever by words, either by spoken or written, or by any signs, or by visible representation, or by any otherwise, bring or attempt to bring into hatred or contempt or excites or attempt to excite disaffection towards the government established by law in India. So this is a way. So what kind of it will be by spoken words or maybe any kind of a activity by sign, by graphical representation, or can be defaming or a kind of a caricature, or maybe just using or inciting or just creating any kind of a hatred, so maybe against the government, so that that be government established by law. This is disaffection towards the government or established by law in India. So that's why this section will just 124A will just whoever indulge, whoever act against the government of India, or maybe person who is an authentic person, who is government of India protects the sovereignty and integrity of the any person. So the not sovereignty, integrity, any person's defamation, any kind of any person that is defaming, who is occupying the position, guaranteed by the constitution. So this can bring into the force this 127, 124A section. The another section is 292 IPC Act, so Bharat Nyaya Samhita Act punishes sales and distribution and exhibition of the obscene books and material. So whoever circulate, whoever distribute, whoever just promote obscene books. So who also these acts come into force. And Section 9293 punishes such sale, etc., to the young persons below 20 years of age. So this section punishes whoever sell this kind of books to the youth below 20 years age. The censorship is practiced in India by institutions such as CBFC, Central Board of Central Bureau of Film Certification, established under the Cinematograph Act 1952. CBFC is a film regulatory body which is not only adheres to the standards of censorship but is also rigid about these standards. So these standards there is an institution that practice the censorship practice by the Central Bureau of Film Certification. It will just overlook and just it has the authority just follow certain kind of rules, certain kind of standards. So just any kind of feel, deem and feel, believe any kind of act. They this institution you can censor the certain kind of elements and acts as well as the cable. Next in this there is a those who, that likely to just control the electronic media. Cable Television Act includes something called the programming code. So programming code is been enshrined under the Cable Regulation Act. From time to time, it was modified. It will actually it was brought into the act in 1995. Then again, it will just modify 1997 and 1999, and again in 2009 and 2012. So from time to time, it will be just modified. So that was there are just certain guidelines that the programming code was enshrined in this one. So whoever just making a program or maybe developing a content on television or maybe telecasting and broadcasting and maybe transmitting any kind of a content that is infringing, that is violating the programming code. So that like that kind of a that particular channel, particular news content, particular news item and program, so likely to just attract the ire of the government of India and the Ministry of Information. There is a specific monitoring cell is there, so it will continuously watch the programming that is broadcast in India and uplink in India and downlink in India. So whatever content, whatever the program that is broadcast, so it will just continuously monitor and continuously see the whatever the program is made and broadcasted. So it will see whether it will be following the programming code enshrined in the Act, Cable Regulation Act, Cable and Television Regulation Act. So such kind of a act, such kind of infringement, it will likely to just get the notice from the government of India. So that is the way how it will be just news channels as well as the programming, all news channels as well as current affairs channels and other channels were supposed to follow the guidelines. It acted as a tool to curtail and prosecute the opposition. So there is an allegation as well as certain kind of a channel, certain kind of a news broadcasted. So there is allegation that means they are using this programming code to just use prosecute the opposition parties, opposition leaders as well as also has been used to regulate the news portals during the terror attacks and such as Pathankot in 2010. It will happen in 2010, 2016 as well as and also certain kind of a guidelines also just made. So we have just seen the Mumbai terrorist attack. So during those days as well as the kind of a coverage, the kind of a way where you try to just focus, try to just concentrate the activities government how just in order to just counter act with the terrorism acts the people are doing the live telecast of such a kind of activities, the mobilization of the forces telecasting such kind of a news. So there have been few national broadcasting service in sorry National Broadcasting Association is there. They are made certain kind of a guidelines. Whoever just involved in certain kind of a activities, certain kind of a broadcasting. So that is related to the any kind of a terrorism or maybe any kind of a forces mobilizing to just counteract the terrorist activities. So such kind of a acts should not be telecasted, should not be live telecasted. Such kind of a guidelines were formulated by the National Broadcasting Association as well as. So that's why so the kind of a guidelines was formulated. Next, the censorship with regard to the films in India. So there are many categories, the four categories under this, Censorship Act, and the CBSE issues the certificates. So U is an unrestricted exhibition. So anybody, there is no restriction in the exhibition of the films, videos, and documentaries. And then there is, one UA is the unrestricted exhibition except for children below the age of 12 years. So there is, another is, A. So another is, restricted to the adults only. So this will content will be for only for restricted for the adults only. And there is a other category is the S category. S category is restricted to the specialized specific class of persons, where specific class of persons for just be able to just view. Maybe it may be doctors, it may be kind of a particular section of the society. They will be restricted, only they can be able to view certain kind of a content only. With regard to the visual content which could trigger trauma content, such as, scenes that are often a part of the action films or films surrounding mental health, and there should be content warning this. So there is a, so certain kind of a element, certain kind of a activities, certain kind of a scenes which feel some kind of a horror, or maybe scenes, or maybe kind of a mental trauma, and some kind of a triggers mental trauma, or maybe scenes which will be filled with, horror, or maybe kind of, aggressive kind of a nature. So for such kind of content, there should be a warning, a disclaimer warning should be there. There's certain kind of a scene, certain kind of a element, certain kind of a content in this video. So you should not, those who are, soft-hearted should not watch. Such kind of a disclaimer should be, such kind of a warning should be displayed before, uh, just need to display the disclaimer initially. Next, moving on to Drugs and Magical Remedies Objectionable Advertisement Act 1954. This is a one side of, drugs and magical remedies, where, certain kind of a claims, certain kind of products, all promised or just highlight that this kind of a, if you use this kind of a products, this kind of a purchase, and you consume this kind of a drugs, you can just get immediate relief and immediate kind of, magical remedies as well. As so, for those kind of claims, this kind of exaggerated claims, to just to in order to just control such kind of exaggerated advertisements, this act was brought into force. So drugs, it will be considered, it will be called as, Drugs and Magical Remedies Objectionable Remedies Act 1954. So is the act of the Parliament of India, so which controls advertisement of drugs in India. It prohibits advertisements of drugs and remedies that claim to have magical properties, and makes doing so a cognizable offense as well. So provision of a misleading advertisements related to the drugs. No person shall take any part in publication of an advertisement relating to relating to a drug, if the advertisement contains any matters which is directly, indirectly, gives a false impression regarding the regarding the true character of a drug, or make a false claim for the drug. So is the otherwise false or misleading in any material any particular way. So any kind of a information, any kind of a promise, any kind of a exaggeration. So using the ads, using the words, using the content to just claim such kind of a, making such kind of a claims, that will just give you the immediate relief, as well as make you like, unwanted kind of a, it's not reliable. Whatever information you will give, it will be given in a logical manner, in a reasonable manner, so that can be have certain kind of elements, that kind of uniqueness, that you can able to present your USP as well as. Yes, somebody is making any kind of a, oh, no props, uh, any kind of exaggerated claims. So such kind of activities will be, just this act will just cover those who are just making such kind of exaggerated claims. So next, what kind of a penalty will be imposed? So whoever contravenes any of the provisions of this act can be punishable with a maximum imprisonment of 6 months with fine, or with both, or if it is repeated, the imprisonment may be extended to 1 year, or with the fine, or with both. So any kind of a fine, it will be, the act will punishes whoever may indulge in kind of a such kind of a exaggerated claims. So offenses by any kind companies as well as, so if the person contravening any of the provisions of this act is a company or a person who at the time of offense was committed, was in charge, or was shall be deemed to be guilty of the contravention, and shall be liable to be proceeded against and punishes accordingly. So whoever is the responsible person at the time of telecasting, at the time of the printing of the particular claim, particular product, a particular advertisement, so that will be who is in charge at the particular time. So he will be punished. He will be in the process. He will be shall be deemed to be feel deemed to be deemed to be guilty, and just should be likely to be punished. So this is a penalty. How it will be, this act will just go on and just cover the exaggerated claims. This, I mean, all corporate companies, whoever will make this kind of a claims and making the false promises as well as. So next, moving on to the Children Act 1960. So what is the Children Act? What it will tell about? What are the, I mean, procedure? What are the points? What are the aspects it will highlights in this one? The Children Act 1960 provides for the care, protection, maintenance, and welfare, and training, education, rehabilitation of neglected delinquent children. Or delinquent means here those who are involved in the crime kind of things, maybe robbery, theft, so any kind of a crime. So that is called, I mean, delinquent children. For the trial of the delinquent children in the union territories as well as. So this act will covers the protection of the such kind of a children. So who are, I mean, just below the age of 18 years, who will involve in this kind of a crime activities. So such kind of a people, such kind of a children, they will be rehabilitated. They will be provided welfare activities, welfare, and will be given a training as well as. This act provides for establishment and appointment of certain institutions and authorities like child welfare boards, children courts. The boards, or I mean children court, has been constituted for any area, have power to deal exclusively with all proceedings under this act related to the neglected children or delinquent children, as the case may be. The Act also empowers the administrators to establish and maintain as many children's homes and special schools, observation homes, and after care organizations as may be necessary for the reception of the neglected children as well as. So this is the way how it will this, I mean, Children Act 1960 will just highlight those who, when this those children below the age of 18 years who committed, who is neglected, who is, I mean, they are in a minor, they are considered as a minor, they will indulge in the certain kind of a crimes. They should be provided, they should be given equal up, they should be given training as well as the education as well as to just protect them. Next, prohibition of this, and also what are the, I mean, kind of way. So those children who was involved in such kind of a crime activities, they should not, name should not be published, involve any proceedings under the Act 1. No report. So under this act, no report or in any newspaper, magazine, or news sheet of any inquiry regarding a child under this act shall disclose the name, address, school, or any particulars circulated or calculated to lead to the identification of the child, or shall any picture of a such a child to be published. So not punished, published. So any particular identification of the particular location, address, and the image of the particular should not be published in any newspaper, any channel, any digital platforms, provided that for the reasons to be recorded in writing, the authority holding the inquiry may permit such disclosures. You need to take the concerned authority before publishing, before disclosing such kind of a information. If in its opinion such disclosure is interest of the child, so so interest of the child, so the authority may shall believe that when in the interest of the child they can disclose, then the whoever publishing, whoever broadcasting such kind of information, they need to seek, they need to take the permission of the concerned authority. Then only they will need to publish such kind of a information. As well as any person contravening the provisions of the act shall be punishable with fine which may extend to 1,000 rupees. So that is the way how it will be just take. This act covers and juvenile justice, care and protection of the Children Act 2015. So that also juvenile justice. So whoever delinquent children, whoever just involved in kind of a crimes, for them there is a specific justice. Juvenile homes are there. Juvenile Justice and Care Protection Act 2001 was repealed, and Juvenile Justice Care and Protection Act has came into force in 2015. Under the section 15 of the Act, special provisions have been made to tackle child offenders committing heinous offences in the age group of 16 to 18 years. For them, there will be special juvenile care centers should be there. All child care institutions, whether run by state government or by voluntary or non-government organizations, which are meant either wholly or partially for housing children, regardless of whether they receive grants from the government or to be mandatorily registered under the Act. Stringent penalty is provided in the law in case of non-compliance. So those who are not able to follow the provisions, those not able to follow the guidelines, such for persons, the stringent penalty will be provided in case of a non-compliance of the act. Next, so defamation. So what is the defamation means? So any person. So defamation is overall written statement that hurts someone's reputation, where reputation is considered as an integral and important part of the dignity of the individual. A right to reputation is inherent right guaranteed by Article 21, and it's also called the natural right as well as. So that is a way. So in defamation is covered. Defamation, how it will be any publication or oral statement or written statement that is affecting the individuals or maybe institutions or maybe reputation of the any person considered to be defaming the particular dignity of the particular person. So that way the law of defamation will come into force. So in India, defamation can be viewed as a civil offense as well as a criminal offense. Maybe defined as a writing publication speaking of a false statement which causes injury to reputation and good name for private interest. The remedy for civil defamation is covered under law of torts. In civil defamation, a victim can move high court or subordinate courts for seeking damages in the form of monetary compensation from the accused. So civil defamation, the person can approach civil any court, so high court and any subordinate courts for getting the monetary compensation from the accused, whoever made such a kind of allegation, such a kind of accusation. So section 499 and 500 of the Indian Penal Code provides an opportunity to the victims to file a criminal case for defamation against the accused as well as. So this section also just gives the for 499 and 500 also give the particular person, so he can also approach the court. Punishment for the guilty person for a criminal defamation is simple imprisonment which may extend to 2 years or fine or both. So under criminal law it is bailable and non-cognizable and compoundable offense as well as. So that is why definition law of defamation is covered. So that way law of defamation is given given. So there are certain kind of information where you able to just in this defamation case. So there are so many cases are there. So there is during Corona as well as certain cases. Those who are Bharat Biotech. So when one article is published in the when reputed Telugu newspaper. So in this article, they are just published that they are not followed certain kind of a guidelines. So there's a kind of a trial is not properly conducted. So without proper trials, proper procedure follow not following the certain kind of a procedure, they brought about the the vaccination. So that article, so the particular Bharat Biotech company just, filed a defamation case in the court and asked for the huge compensation. So that kind of incidents happen. So one more kind of such kind of incidents happen in Times of India, Times No television channels. So where horribly there is chit fund scam was happening in West Bengal. So during that chit fund incident. So unknowingly or knowingly, is the Times know what they have done. That they have just picked up in a photograph. Have been a related judge. So hurriedly they have just broadcast that particular image. That particular person also involved in the chit fund scam. So that after the retired judge has seen that telecast. Just on Times Now, and immediately just filed a defamation case against the Times Now channel as well as. For that, he's demanded 1 crore rupees. I believe it will be around 50 lakhs uh, for as a company, a monetary compensation. So after Editors Guild of India that interfered and just requested judge to just think about again. So they have just one trainee journalist has done hurriedly, so without knowingly, so he has been in hurry, he has done committed such kind of a act. So just please think about thing. So after so much kind of a persuasion, so much kind of negotiation, he just convinced and just got the compensation of 10 lakh rupees. So that is the way how the defamation, the kind of way it will just try to just defame the institution as well as defame the particular image as well as. So whoever likely to just involve in the who is in the profession of the journalism, so they need to just cross check before proceeding and just before publication of any kind of article, any kind of information, any kind of image. So we need to check the particular person. So one more instance happened in Telugu television channel as well as. So one person, there is there is allegation that one person was involved in the sexual scandal. So they are just hurriedly they have misused the other person image. So within minutes they are just immediately removed such a image content. So that's highlighting the one particular person, one reputed person also involved in the scandal, sexual scandal. So that kind of a hurriedly, that kind of a without verification, that without cross checking, without in order to sensationalism, in order to just make this also one kind of the yellow journalism we will call. Without verification the false, without verification of the news content, what we'll do, we will just concentrate in order to just get more TRP, in order to get in a hurry, in order to give first to break the information, to just broadcast information. So in order to be first to just telecast that kind of activities without verifying, without checking such kind of information, they will indulge, they will just hurriedly they will broadcast. So that kind of information, that kind of a false information, that way create chaos, and they will the organization, the institution has to face the defamation cases. So such kind of activities, such kind of a acts, so many acts are there, so many examples are there. When we go on, just we can also just describe discuss this kind of act as well as. It happened in print media in Telugu as well as national channels as well as Telugu channels. So even digital platform also just they hurriedly done, and immediately they have removed the content as well as. So that way, the other way, the institutions, it will be affecting the institution, it will be affecting the individual person's reputation. So that is the main kind of things. Before whatever we will publishing, whatever we will broadcasting, we need to continuously cross check. Even if it related to any kind of a scheme related to the government of India, there is press information bureau is there. So if you want to just cross check the information there also, you could just send your query to the press information bureau. There are also fact checking there. They will check and just let you know the what kind of information is there. So whether which is correct, which is true, that information. So that's the way you need to just verify the kind of content as that. So next class we'll just cover the next remaining units. So the remaining 2-3 units are there. So we'll cover, and also the whatever the left out we'll discuss in the next class. So thank you for attending so patiently, listening to my lecture. Thank you so much.
Thank you very much, sir. Thank
We'll be
you.
having the next class. So join that next class. Okay.
Yeah.
Thank you.